Welcome to Direct Examination presented by UBS. Along with Lauren Youngman from Youngman Reichstein, I'm Dan Bemel, financial advisor and certified divorce financial analyst at UBS Private Wealth Management. This is our first episode back after a little break, and we're excited to bring you new interviews and roundtables from the world of family law here in Los Angeles and across the country. But we're going to start by bringing back our absolute favorites.
Thanks, Dan. In the spirit of the Beverly Hill Bar Association State of Department 2 and Annual Awards Dinner, today's episode is a Legends Roundtable. All three of our guests are true legends, but of course our Bar Association award makes it official. Receiving the honor this year is Larry Ginsberg of Harris Ginsberg, who joins a group including not only today's guests, Neal Hersh of Summers, Levine, Lipsick, and Hersh, and Alexandra Leichter of Leichter Morocco, but renowned practitioners including Sorrel Trope, Dennis Wasser, and Joe Manis, just to name a few.
So thank you all for being part of this special roundtable episode. Let's get started with an obvious question. Larry, how does it feel being part of this group?
Obvious question, not such an obvious answer. It's humbling. It's weird. It feels like I'm still the new kid on the block 30 some years in. So I can only imagine how Alice and Neal must feel about it. But I've always looked up, with incredible kind of in a mentoring way toward, Alice and Neal and the other honorees, and Sorrel, of course, had a long relationship with. So, to be one of this list, I'm not sure yet what legends actually means, but I think the countenance and the aura of the other previous recipients kind of defines that. So I'm very humbled. I'm honored that it's kind of a place for my career, a place marker for my career, if you will. Alice and Neal can tell us if it all goes downhill from here, but I certainly feel honored and humbled and grateful.
All right. Neal, do you remember the first time you faced Larry and Alice in court? What was that initial reaction?
So I actually don't remember the specifics, but I remember being in court with both of them. And what I would say, being serious for a moment, is that with both of them, they're fierce advocates, always prepared, always respectful, and having a case with them was challenging because they were very good at what they do, but always comfortable because you knew that you were dealing with very, very smart, intelligent, but people who are very civil, and we operated on a very lovely plane. So it was really a pleasure, despite the fact that these cases can be difficult. Alice is a fierce litigator. It's just amazing. And Larry, I think he's a little bit more softer in some ways with his approach, but when they get up and they speak, they're something to be reckoned with, absolutely, for certain. So I don't remember the cases and the names because I sort of, purge these things, but I remember specifically the interactions for sure.
As financial advisors who specialize in divorce, our team's first priority is to help family law attorneys get the best possible outcome.
And we strive to help clients be better partners in their own case through education and support. The forensic accountants build the balance sheet, but we are your translators, teaching the basics to clients who may have limited financial experience. And then we look behind the numbers to find benefits and avoid traps so you can negotiate a better deal.
Real-time financial analysis gives clients an anchor in what can be a fast-moving and confusing experience, connects the balance sheet and legal strategy to real life, and answers the fundamental question, will this settlement be enough? We run Monte Carlo simulations as negotiations develop, controlling for even the most granular aspects of a proposal. This changes the dynamic in the room and empowers clients to focus on their next chapter instead of just on the fight.
Engaging with financial issues early in a case is the key to long-term success. And as the case winds down and you pass the baton, we monitor the deal to ensure all your hard work has a lasting positive impact in each client's life.
Working together adds firepower to your team and brings a depth of knowledge and advice in service of better outcomes and more satisfied clients.
All right.
Well, in other words, what he wanted to say is Alice is a bull in a china shop.
So, well,
now,
Alice,
you know,
let's turn to you. What's the main difference between working with or really against Larry and Neal and in a real people who aren't Larry and Neal?
Oh my God, a lot of difference. First of all, they're both gentlemen in the very oldest sense of the word. It's a pleasure to litigate against them. They're not going to screw you over with something that comes out of left field. If there's something that they think is going to be presented that they know I don't know anything about, they will let me know. This isn't family law, unlike litigation in civil cases and personal injury and medical malpractice, all of which I have done. There you're fighting against the other side. Here, at the same time that you're fighting the other side, you're also trying to preserve the dignity of your clients and the dignity of the other side. So it's not the same thing as litigating in a civil case where you go to the nth degree. And Neal and Larry are the epitome of gentlemen and understanding what it is to litigate a family law case and still preserve the dignity of the clients.
So, you touched on this, Alice, already, and you've all worked cases against each other many times, often high stakes and contentious between the parties, at least, and including a pending case right now. And I want to dig in there a little bit more on the actual practice. And this is obviously such a love fest. It doesn't have to be necessarily working against each other, but when you have professional respect for opposing counsel, especially at the level that you three have for each other, how does that shape your strategy during a case? Larry, why don't you take that one?
Yeah, thank you. I say to clients all the time as we're getting into the process, there are a couple things that I value the most about having counsel on the other side, like Alice and like Neal and several others in our community. Number one is the ability to pick up the phone, have a conversation that's a real conversation without feeling as though you're somehow handing them information that they will use against you. You have to have that level of trust on a professional level, which certainly the three of us have, and we have with many of other colleagues. So what shapes the perspective in the process is that the ability to pick up the phone and have the conversation. So I'll say to clients, two things. Number one, I'd much rather have an attorney on the other side of the case who knows what he or she is doing. Much rather have someone who knows the business, knows the practice, knows how to choose their battles, knows how to graciously accept, we don't create the facts that walk into our office. So let's accept the facts that we have, figure out how to work with them in the context of the law and the circumstances, but also then to be able to say to that opposing counsel, as Alice has mentioned, this is coming up. This is my client's position. We are advocates for our clients first and foremost, but to do so respectfully, with grace, if I may use that word, and with a sense of professionalism that serves the profession, serves the client, serves the family, serves the bench, so they have respect and gravitas for you in the presentation. These guys and many other folks, again, in our community, allow that to happen, knowing that that is my opposing counsel, knowing that is someone I can have a conversation with and battle out as vigorously as we need to serve the advocacy of the client, but to say you did a good job or that was a point well taken, and to be pragmatically realistic about the outcome is key. And these guys have that in spades.
Alice, how do you separate competition in the courtroom from collaboration outside of it?
Okay. You know how we have this meet and confirm, meet and confirm, meet and confer, which I frickin' hate. And the reason I hate is because you're going to force us to send emails to each other saying, can we do this? Can we do that? And nothing gets accomplished. What is important to me is that I have the ability to pick up the phone and tell these guys, let's go to breakfast. I want to discuss something with you that's very important to my client, and I think it's important in the way to resolve the case. With these guys, I don't have to worry about them turning the knife into me because I picked up the phone and I said, let's go to breakfast, lunch, dinner, whatever it is. I think that personal interaction between attorneys is so much more important than this quote meet and confer. That's why I yell all the time that when we have cases in court and it's all on Zoom or whatever electronic thing, we don't get to see the other side, really. We don't get to see the judge except the profile. We don't get to see how the judge thinks, and we don't get to see how the clients think or how they do. We had a much easier time in settling cases and not having to go to court when we had the ability to talk to each other. Talking to each other is far more important than this meet and confer bullshit that everybody is pushing on us. Does that answer the question?
It does.
I
and
think
we
it
won't
does.
bleep.
How do you feel about meet and confer? I think we can skip that one. But Neal, Alice talked about working on the sidelines, but when I've gotten to know you as just a brilliant tactician. So when you're in the middle of a case or even preparing for a case, and you're working with people or opposing counsel or people like Larry and Alice, does that change how you prepare for the case? Do you anticipate particular moves or tactics from their side, or are there moments where your knowledge of their strengths or weaknesses might change your positioning?
So let me, before I answer that straight on, I wanted to say one remark. Larry worked with Sorrel Trope. I worked with Simon Taub. These guys were from the old school. Like Alice was saying, gentlemen, first and foremost, always civil, except when they got in the courtroom, they were fierce advocates, like Alice and Larry are. So moving toward your question, yes, with Larry and Alice, they could call me, take me to lunch. But if we don't resolve a case and I go into the courtroom with Alice, I know she's going to try to rip my head off to win her case, as is Larry, as am I, but not rip our heads off and be mean-spirited about it. Know that it's business. I mean, it's just business. That's just sort of so we have to do our jobs for our client, but we have to do it with civility, respect, and keep that as our benchmark. So when we leave, I always say when we're dealing with sort of celebrity clients, at the end of the case, you have to do a good job, but you can't ruin their career with bad publicity. So you're doing a dance with people we know and we love and who have been in this business, like Larry and Alice. When we're done with the case, we could give each other a hug and mean it and go on as if what happened in that courtroom never happened, and know that that's okay. And that's, in my opinion, the difference of people who have respect for one another, like I do with these two, and those who don't. There are people who would like to see you as roadkill and never look back. That is not how we operate with people we know and we love and respect. And so, yeah, I could try to guess Larry's strategy or Alice's strategy, but we all know what we have to do in a case to do certain things, and we can anticipate that. So we do. But, that's, I don't say, oh God, I'm going to do this because Larry's going to do that, or, Alice is going to say this. So that's not how I work. I know they're going to do a thorough job for their client. Rarely can I surprise either of these two people with something that I'm going to do. It's possible, it's possible, but probably not likely, because they've seen it all and done it all. And they're probably not going to surprise me, tremendously. They could. And that would be kind of fun, because it would be like, oh God, that's a benchmark, right? So we sort of know how we go about litigating a case. So I'm not focusing on surprises from them, but really how to interact with them as Alice and Larry said, see if we can accomplish a resolution for the benefit of the client. And if not, go into court, advocate for our client vigorously, but leave that court as if we were having dinner with our families because we're friends. That's really how I see it.
May I add something to that?
Absolutely.
Lauren? It's so important, I think, and I have this conversation again with clients all the time, in a difficult context of a divorce, of a separation, of all the stuff that floats to the surface during that process. Obviously a lot of anger, betrayal, issues that have been long percolating. And I say to clients, number one, don't expect me to adopt the hostility or anger, whatever you may have for your spouse or whomever it is. Don't expect me to adopt that in this context of my relationships with Neal, Alice, and others. Don't expect me to adopt that for the purposes of accomplishing your goals. If you do want that, I can give you the names of some lawyers to go hire, but I'm not that person. But to make them understand, or try to get them to understand, that the civility, the professionalism, the measured approach, the measured presentation serves their interests, so that the bench, if it gets to trial, or the mediator, if it's in mediation, or even as to each other, they know you're serving the purpose of the ultimate goal of resolution, with the vigorous advocacy that goes with that, but in a way that is not, to Neal's point, going to leave someone as roadkill by the side, a professional that you are working with and going to work with likely in the future as roadkill, in your wake. So that's, I think, extraordinarily important.
So, Larry, how do your clients take that when you say, I need to not adopt your, as I think the term was used before, rip your head off approach, and, not leave them as roadkill? Do you find that you have a lot of resistance from your clients, or do they tend to see the value in you having a collaborative relationship with the other side?
They tend to see the value, whether in the short term or the long term. If my impression is that this is someone who will not work well with the way I work, then my advice again is, let me give you a list of people you might hire. And I usually say to people, it will probably cost you a lot more. You may end up with a worse result. However this process is, you will certainly end up with a worse relationship with your former partner, husband, wife, significant other, whatever, and potentially with your children. But you, and I try to say this in a non-pejorative way, you may feel better about it. And if that's what you need, then again, my mother-in-law likes to use the phrase, water seeks its own level. I think that applies to lawyers and clients. And a client may have a different view of me or Alice or Neal. And if they feel the need that someone needs to be bombastic and waving their arms about and denigrating the other party or the situation, again, you will not feel well served by me, because you're not going to get that process from me. And usually after a couple discussions, and kind of really fulsome discussions, I think people mostly get that, particularly at the level of practice that we all are engaged in for the most part. But if I'm feeling that resistance, and my assistant is a much better gauge of that than I am, she'll be the one who says this is not a good idea, you shouldn't take the case. The productive nature of it and the ongoing discussion of it is important, because, as we all know, hurdles come up, issues come up, and it's important to remind the client that while this is difficult and you want to lash out and you want to kind of burn the house down, let's talk about how that serves your and the families and the children's and the relationship interest going forward for the next 20 or 30 years. And usually people are fairly willing to hear that, even with the bumps in the road.
Larry is a lot nicer than I am. I just say, don't let the door hit you on your way out.
Well,
Neal, did you want to add something?
yeah, so part of the benefit of aging in this business is we are all, and by the way, this shouldn't happen. This should not only happen because of age or experience, it should happen all the time. But certainly at our level, we have the luxury of saying to a client, no, thank you. So a client comes to us and wants us to represent them. We get the right to say, this is not a good fit for us. So if I think a client has ridiculous expectations, or I'm not going to be able to meet them, or like Larry said, want something from me that I'm not able to deliver, whatever that is, the same, respectfully, we have to send them on their way. And it's kind of a freeing feeling to say, we don't have to take every case that comes in, and we don't have to listen to clients send us on a path that isn't in keeping with our makeup. And that is, a benefit of sort of growing up in this business and seeing that if you don't do that, it takes something out of you, personally as well. And the clients, what if someone is looking for that roadkill and they want that and you don't give it to them 1 second, it's what have you done for me lately? They're not happy with you anyway. So, we have to, as Larry said, tell the clients what to expect from us. But if it doesn't meet with our, internal mechanism, I won't take a case, for example, a custody case where I think the parent who comes in is asked for something that I think is ridiculous or inappropriate or whatever. I don't need the aggravation. I'm not going to be happy getting the result, even if I got it. So I don't do it. And if someone doesn't like it, like Alice said, there's the door. And like Larry said, here's a list. So be on your way.
So I think that's a really powerful insight for I think people practicing now, really in any business. What other insights, Neal, have you picked up from practicing against the Larrys and the Alices of the world beyond kind of the client management piece?
There are no other Alice and Larrys.
Okay, stop.
So when I was, thinking about this podcast, when we came up, and I sort of hate saying this because I used to hear Simon, my old mentor, say this like in the good old days, right, and so on. And Alice is talking about before we had electronics. But in the good old days, I am saying what I loathe saying, so to speak. Preparation was everything, right? You just had to prepare. And why is that? I'll tell you. For me, if I'm not prepared, I don't feel comfortable in my own skin or confident, and that shows, right? You go to court, you need to show your client, the other side, that you're confident in what you're doing. So even though I think I know a lot, I actually know I don't know a lot too. So every time I have a case, I go back to the well and I read this stuff over again. I would say this crap over again. How many times can you read about goodwill or, this or that? But I have to do it so that I can, know that I'm going in as prepared as I can be. I know these two individuals are prepared. I know they're smart. And what I've taken for all these years of practice is there are no shortcuts, period, full stop. And so when you get these young people who may think they know it all, they're trying to prove something, and they're, just coming in to be the shootout at the OK Corral, that's not how these people work, nor do I think it's appropriate how the law should be practiced. So what I've taken from them is model their example. I mean, they are completely prepared, completely ready to go. And as I say, it's done in a way that doesn't have to be, inappropriate in terms of the style. And it's just done thoroughly and completely, period.
Well, I want to pick up on that because up to this point, we have been talking about the three of you. We're mostly working with each other, the best of the best. But let's kind of pivot. And Neal, you open this up, and when that's not the case. So when there is a massive difference in experience between attorneys, Alice, how does that change your approach to a case? And do you alter your strategy when going up against somebody who either has the roadkill approach or just isn't a legend, doesn't have the same experience or history either in court or with you?
Well, first of all, no one else has this kind of experience because as far as I know, no one else has 53 frickin' years of experience doing this. But I have to tell you that when there are attorneys on the other side who may not know the law, I do talk to them and say, take a look at this code section, take a look at that, because there's no point in going to court when I know, I was going to say when I know I'm right, when I know that the law is on my client's side, or when I know the law is against my client. And it is a lot easier to go in front of a judge, especially a judge who is inexperienced in family law, and be able to present it. And yeah, I have white hair, I understand that, so I get a little more respect for this old age. But that being said, I think the important thing is to get the case done. And there's no point in killing the client while you're winning the case. And that's the whole thing. That's exactly what Neal said and exactly what Larry said. And I have to tell you, among people who have been doing this for a number of years, they will say the exact same thing. Don't kill the messenger. Don't fight with the other side for no reason whatsoever. That being said, I've had recently a number of experiences where some attorneys feel that they have to go and get upset or get angry or fight with me, I guess because of my old age, and they figure they'll wear me down. I don't know. But when I try to tell them, look, this is not going to help the client. Can we do it this way or that way? Some of them say, screw you and the horse you rode in on. Others are, and I've done a lot of mentoring. I've had mentoring groups of young attorneys. I've had groups like for 2 years or 3 years at a time, and we meet once a month and we get to talk about certain things, and I would teach them some of the things that I learned. And I think it is very important for younger attorneys to be involved with mentoring programs like that with older attorneys, because we can teach them not the law, that they can pick up, but the way to handle the case, the way to negotiate. Negotiation is very, very difficult, especially when they adopt their own clients' attitude. So I think that's a thing that you've got to take a look at, and that's the way to handle the situation. Not always easy, I will tell you that. But I agree with Neal and with Larry that the only way that you're going to get anywhere is if you can get the other side to understand that their client has at least as much to lose as yours.
I just want to
Go ahead, Neal.
throw out a story that these guys will appreciate. When you talk about
Are we involved in the story?
no, but you may know you will know who was. So
Okay.
you're talking about how you deal with an inexperienced lawyer. I was working for Simon Taub. I was a lawyer for a year, maybe less. He sends me to court on a custody case with a lawyer named Joe Tabak, who was a fierce guy in court, fierce. And I knew nothing what I was doing. Okay. Simon said, just go in, it'll be okay. Don't worry about it. And I went, it was a hearing. I think it was, I don't know if it was an evidentiary hearing or just an argument. No, it was a hearing. And he was obliterating me. And every break, this is an absolutely true story. He would take me outside. You could smoke in the corridors in those days. And he used to smoke cigars. He'd light a cigar and he'd put his arm around me and say, Neal, that wasn't too bad, but you need to look at evidence code, blah, 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 and just focus on that a little bit. And I'd look at him, so thank you, Joe. And then we went back and he was beating the daylights out of me, and it happened again. And finally I said, what are you doing? I mean, it's like he's Dr. Jekyll and Mr. Hyde. He said, that's in there. This is out here. We became fast friends. And I'm going to tell you something else he taught me. Just shows you how you learn things. I went to a seminar, a CLA, it was a CFLR seminar back in the day, a weekend seminar. I sat next to him because now he was my buddy, right? I looked up to him. I learned a tremendous amount about trial practice by watching him. But here's Joe at this seminar, and he was taking notes the entire weekend, every single word, almost like shorthand. And he taught me when I was in trial, I try to do the exact same thing, not so much anymore because someone's next to me taking it on the computer, but I used to take copious notes. And he said, that's how he learns. That's how he gets his cross-examination ready for the other side when he's doing it. My point is, this was a guy who I didn't work for him. He didn't know me the time of day. And he sort of just nurtured me inadvertently, let's say, and taught a young guy who knew nothing certain tactics that I carry with me to this very day. And I thank him to this very day. So yeah, it's our obligation to tell somebody young or try to help someone younger than us with not only the law, as Alice said, but also the way of practicing, and teach somebody that what goes on in the courtroom while I'm getting my head chopped off isn't the full nature of the man who's chopping it off. That's for sure. So that's my sermon for the day.
And my experience with Joe Tabak was identical. He wiped the floor with me in court. Then we walked outside, put his arms around me and said, Alice, that was the best cross-examination I have ever seen. I said, what?
Yeah. Yeah.
That was Joe.
Yep.
Let's
Loved
just
him. Loved
Larry,
him.
Larry,
one
let me jump
comment.
in. Let me jump
Yeah.
in. Larry, what's your take on this topic? Have you found yourself either being mentored by an opponent or doing the mentoring yourself?
Oh God, I could give you so many examples of being mentored by an opponent. The one that really sticks out that I like talking about. I want to make one comment first before I forget it, because I will forget
Sure,
it.
sure.
It happens, and then I'll get to the little bit of a comment about the war story. About the younger lawyers. I really want, and I'm not sure how to say this in a way that doesn't sound pejorative or perhaps patronizing, with younger lawyers, say, how you, and we've all gone through it. We've all gone through it. How you treat others, how you act, how you participate in this process in the early days, people remember. Opinions are formed. The kind of strategy and discussion and negotiation and context has an impact. And I just want people to be thinking about, as younger lawyers, and I think, Alice certainly does. Neal and I both do a lot of mentoring with both within our firms and outside of the firms, and talking to, large groups of people. Just take that deep breath and realize that it's not the person. It might be the advocacy interest. It might be other dynamics that are going on. But I think it's really important for people to remember, we all have long memories, for the most part, of those kinds of actions. But the little war story about being mentored by an opponent, I was a very young lawyer. I was trying, it's a reported case in California called Marriage of Dick, Elizabeth and John Dick. Sorrel was my mentor, and I was a young associate at the time with Sorrel. We were representing Elizabeth Dick, and Steve Kolodny, may he rest in peace as well, was representing John Dick. And it was a contempt. It was being tried in front of Les Olson, who at the time was retired but sitting by special assignment or something, can't remember. And I was there with Sorrel, and Steve Kolodny's there, and I'm like, second-year lawyer, whatever it was. And I presented some initial motion or something, and Sorrel was going to try the contempt. But as then I was finishing with my motion, Judge Olson says, no, Larry, you go ahead and proceed with the contempt against Steve Kolodny. I was a second-year lawyer. It's a big case. Sorrel's there tugging at my coat the entire time, my jacket the entire time. But the best moment was after we were able to be successful in the contempt with John Dick in absentia, leaving the courtroom. Steve Kolodny, much like the experience that Alice had with Joe Tabak, Steve Kolodny, opposing counsel, esteemed, significant, contempt king Steve Kolodny, put his arm around me and said, that was not the best. I was not aspiring to be the best. So that was the most kind of comprehensive presentation and kind of point by point presentation of a contempt that he had heard, quote, from a younger lawyer. So he was going to qualify it. I understand that. But that moment taught me that you could have that relationship outside of court while being a vigorous advocate or doing what you needed to do in court for your client, and still share that moment. And, it wasn't necessarily Sorrel who complimented me, because I think he was still in shell shock that I was told to try the contempt. But for Steve Kolodny to say that to a young lawyer, and it's now 30 some years later, and I remember it like it was yesterday,
Right.
that moment, and taking that moment to compliment someone on a job well done in the context of feeling so kind of terrified of proceeding in that moment, had a huge impact. And that mentoring that we can now share and pass along, I think, I'm hopeful, has the same kind of impact with younger lawyers today in family law.
So, Larry, I want to stay with that for a second with you. You guys have all talked about what you do in the hallway and the impact that your mentors had in the hallway. How do you respond in the courtroom when you see a mistake being made or you see an error that you ultimately correct or help mentor later? But what do you do in the moment?
Cry.
What else?
I said cry.
Well, that's if you're the person coming in and making the incorrect presentation as you're corrected. Because I think that the impression and the impact you have in the court on the bench, on the particular judicial officer. Very important to know who and how they operate, who they are and how they operate. Because that impact is very important for your own client, how you handle exactly that kind of an issue, Dan, I think is crucial. And if you want to leave that younger lawyer as roadkill, I'm sorry we ever referenced roadkill. It's a horrible kind of metaphor, but there we are. If you want to leave that younger person, you can do that. You can completely decimate them in court. What I like to do, and what I prefer to do, because I think judges are much more appreciative of this kind of style, at least for me, I can't speak for everybody, is to gently but firmly, correct I would never use the phrase necessarily learned colleague, but my colleague, my opposing counsel, perhaps is misreading, perhaps is not remembering the application of that particular paradigm or that particular legal theory in the context of the facts before us, but they are incorrect. And here's how they're incorrect. And I don't personalize it to them. I bring it to the court's attention in a way that, and you always know, I can't speak for Alice and Neal about this, but you always know you're making a point when you're having this colloquy with the court and all of a sudden they stop and they write something down. And you've made a point with them, good, bad, or ugly. And the hope is then you walk out of the courtroom and you have the kind of conversation that Neal had with Joe Tabak, and hopefully that person appreciates how you handled that, and they learn that maybe they do that going forward. Again, it's not scorched earth. No one, from my perspective, wins in a scorched earth kind of presentation, and the court, I think, doesn't really respect a scorched earth presentation, but a lot of people like to do that. But I think you need to clearly advocate and clearly point out the problem and point out the misunderstanding. We won't call it an assertive misrepresentation. Now, if you know it's a misrepresentation, if you know that that younger lawyer knows better, I might switch it up. I might become a little more like Alice Leichter and call it out as what it is, because that really shouldn't be tolerated as an officer of the court. But your hope is that, and the assumption, at least that often is, it's a misunderstanding or a misapplication perhaps of the law to the facts, and you point it out in a productive way that makes your point, and then you just shut up about it.
Good to know that you give the benefit of the doubt there and hope that it's just a misapprehension.
But there are times, and I'm sorry to interrupt, there are times when someone knows better, and you got to call that out. You have to, even then, being respectful if you, or whatever you do, but I put in my Alice Leichter hat, call it out, and hopefully they remember that.
Just because I'm a lot older than you and could be your mother.
Neal, for a question for you, have you witnessed the evolution of a less experienced attorney maybe tripping over themselves and going in the hallway and stressing about what's happening on the break and coming back and seen them evolve into a formidable opponent, maybe even someone that you've worked with in your office?
The answer is yes. I think, yes, people in your firm, your associates, the people that you bring into the firm, they come in at one level and hopefully they stay indefinitely, but if they ever leave, they have left at another level. And of course they've evolved. We've seen lawyers in our firm go from, tentative about going to do courtroom work, and trials, starting with the deposition. Even that they're nervous the first time you're doing a deposition. And it's an evolution. I mean, when you're in law school, you don't learn how to take a deposition. You don't learn how to do direct examination, and you don't learn how to do cross-examination. I'll go back to Tabak. He was the man who taught me cross-examination by watching him. There was, in my opinion, nobody finer. Sorrell was also superlative at that. But my point is, there aren't classes to do that. So we have to take our young lawyers and start them slow. When we go to a trial now, that's a multi-day trial, some of the younger lawyers will do a witness or two so that they can stand up at the podium and ask questions and be in that kind of mix. They won't learn it any other way. So yeah, in a word, without being any more long-winded, yeah, we see our lawyers, if all is going well in our firm, and I've seen it with other people, other lawyers that I've come in contact with in the field, of course, over the years, if they're preparing and learning, they evolve into someone better than they were yesterday. And by the way, lest you think otherwise, notwithstanding Alice is talking about her age, or Larry, I'm going to speak for myself, no matter what age we are, We can and we should learn something today and get a little bit better for tomorrow. So that never will stop. And that's my answer.
So we've spent some time talking about working with young opposing counsel. We know there's a lot of turnover on the bench, more now than when you all started, it seems. So you can find yourself not only with less experienced counsel on the other side, but also way less experienced judges staring down at you from the bench. So Alice, what specific challenges we're getting the sense that you're not shy when telling opposing counsel that they are way off base. What challenges and how do you deal with it when you're litigating in front of a judge who's maybe not only new to family law, new to being a judge, maybe both, and definitely doesn't have the depth of experience or knowledge of the code that you do?
That type of a judge is the bane of our existence. And I'll tell you what happens. As a result of knowing there is a judge who hasn't been in family law or hasn't even been on the bench, and certainly has no experience in family law before they got on the bench, we have to dot our I's, cross our T's, prepare points and authorities that we normally wouldn't, because we would know that other judges who are experienced would know everything. Now, keep in mind that when Neal and Larry and I grew up, we had family law commissioners who stayed in the family law bench for decades. And even when they got appointed to the bench as judges, they stayed in family law. They knew every single nuance of every single case. Every time we walked in there, they would say, no, don't tell me that. That's not what that is. This is what that is. Now we have to educate the judges. It costs our clients a lot more. It's very frustrating to deal with judges who are nice and they try and they've had their 3 weeks of training, at the most, I think 6 weeks, but I don't think that's the case. And then they're then thrown in onto the bench, and you have to deal with that. That's an extremely difficult and not cost-effective way of doing family law. And what's even worse, they wait out their 3 years on the bench in family law, and when they know it, because it takes at least 1.5 years to 2 years to really learn family law as a judge, and they learn it, and then their 3 years are up and they go on to civil or who knows where. It's extremely frustrating and very, very expensive for our clients. And sometimes I just want to tear my remaining white hairs out.
So can I
Please
make a
don't.
quick comment?
Yes, Neal, go ahead.
I want to make a quick comment with that. I don't actually agree completely with Alice on this. I do agree that it's different now. But I remember from the time I started with Simon till today, we always said, oh my God, there's a whole new batch of judges. They're not, as familiar as the batch before. Our job is to deal with, the old Paul's Graph versus Long Island Railroad. You deal with your plaintiffs as you find them. This is the judge that we have. We have to educate he or she as best we can. But I guarantee you that the problems that we're speaking about, Alice, about these judges, if they're going to proliferate generation after generation, these young lawyers are going to have the same problem. So we just have to deal with it. There's a bit of frustration, yes. However, I don't see it as markedly different from before. Simon used to be moaned when a new set of judges came in. So I think it's something that is just generational. We just have to deal with it, and we will, and we do.
Well, I just remember the Ken Blacks, the Richard Denners, all of these people who were really brilliant. They were commissioners for umpteen years. They knew every single dot and semicolon in the code, and they would come off to the bench and say, no, that's not the right thing. We don't have that many judges now who are in that position. Hardly any.
Larry, what's your take, Larry, on this? And how do you approach when you have to educate a newer judge or a judge with less experience in family law?
Well, my friendly amendment to my friend Alice's comment is that I don't think it's the bane of our existence as much as, because as Neal says, it's a consistency of our existence. It happens all the time. I kind of, you can look at this as an opportunity to shape the thinking of the court, to not have, we'd all joke about the old days with, Ken Black and Richard Denner and all sorts of judges who, you kind of knew going in a certain parameter kind of what may happen. Here, it's much more of a blank slate, which can be an opportunity for the client. It can be an opportunity for the case, which also ties in, by the way, to whether I'm going up against Neal or Alice or some relatively young lawyer who may not kind of know how to finesse through this process with the new judge. I remember very well the day I went to court and all of a sudden realized, oh my God, I'm older than the judge. When that happens, it's a whole other paradigm. But one thing that I think is important for kind of client management expectations, these kinds of things, when we all have clients who are just focused and singularly driving toward their day in court. And it's really important that clients understand what that means and what it doesn't mean. It's not the Perry Mason moment. It's not, that the kind of drama that we see on television and everything else. And oftentimes over the course of the years, I've had a client go with an associate just on a day of a regular day in court and go sit and watch some judges in action, particularly our judge in action. So when they do go to court with us, they have an understanding of what that process looks like, what it feels like, and that when you are number 7 out of 12 matters on calendar, or number 12 of 20 matters on calendar, and you've got a custody issue and you've got about 8 minutes to argue that, and then to have quote unquote justice meted out by these judges who are overworked and just overwhelmed with the workload, clients need to understand that. And it's all the more difficult when it's a younger judge, I should say a newer judge, less familiar with family law, if we've all had those days when you walk out of court and decisions been made and you're like, what the hell just happened? What was he or she thinking? But you got to live with and explain to your client how that all goes in. And they should understand that before they go in so that expectations are reasonable. But with a newer judge, I think it is an opportunity to say, let's spell this out. Let's make sure that he or she understands. Oftentimes we'll say, let's not bother with a memorandum of points and authorities on a certain issue. Absolutely, with a newer judge, give them something to chew on, and absolutely, more so than with anyone else, give them options. Give them a newer judge. All judges, I think, like options as far as the presentation, particularly with custody and visitation issues. But newer judges in particular, to kind of spell it out and say this leads you to this conclusion, and just be very kind of pragmatic. I think about it like when you're writing the bar exam back in the day, and younger people won't realize this, but there was a lot of handwriting involved in the bar exam when I took it. And the bar, the teachers of the bar preparation courses would tell you, write like you're writing for an 8-year-old. It was simple sentences, underline certain keywords because they, that's what they'd look at. Do the same thing for a new judge. With all due respect to the new judges, they're not 8-year-olds, but they might need that kind of leading along, if you will, to get them to reach the conclusion you want them to reach.
I think we have our headline. Larry Ginsberg says, treat new judges like 8-year-olds. That's, I think that's good.
Thanks for that, Dan.
And we will market this accordingly.
Yeah.
I want to go back. You guys have all talked a little bit about some of your mentors, and I want to unpack that in terms of something Larry just said. There's no Perry Mason moment. The orchestra doesn't swell at mosque. There is no orchestra at mosque, right?
Just across the street.
When you make a great argument, or even when you get a great outcome. But in the context of the Legends Award and the framework of our conversation today, you have had these opportunities to not only learn from people like Sorrel Trope and Tabak and Taub, and partnered with people like Joe Maness, Neal, so that have won these awards, our bar award. So can you tell a story, maybe, Neal, first, of when you felt that inside of you, that orchestra moment from your early on in your career, with not just in the hall, but in the courtroom too?
I'm not really 100% clear on the question. You mean when I thought I did a good job, or?
Yeah, or when you got that feedback from somebody that you thought of as a legend at the time.
Oh, well, so yeah, I mean, I remember working with Simon, and if we had a good result and I did something well, he would always be very complimentary. So I mean, I don't remember the specific aha moment, but I want to say one thing about that too, about our work. In our office, I tell associates, if you're prepared and you do a good job and you come back and you don't get a perfect result, I'll be proud of you. If you don't prepare and you walk into a courtroom, you get lucky and you come back and you think you're hot stuff, it's not going to fly with me. So in our business, our business isn't really binary. Somebody wants $10 a month, somebody wants $20 a month, the judge says 15. Now, who won, who lost? We have to have our own internal metronome for how we measure success internally for ourselves, forget our client. And that, for me, I think it's a job well done. Yes, the outcome is very important, but sometimes the outcome isn't definitive. So, somebody wants 60% custody and you get 55% custody. Okay, is that a complete loss? I don't know. I mean, so I think you have to measure it by knowing that you did a good job and you got the best result, close to the best result you could have. And yeah, I remember certainly, times when, we came back from a court hearing and Simon was very effusive and complimentary. I also remember times when he said, let's sit down and let me teach you how that didn't go right as well as it should. So the moments are on both sides of the aisle. Speaking of election day.
And Alice, how do you measure success when we're faced with that same issue that Neal just brought up, that sometimes it's not so clear who's a winner or who's a loser?
So I'm going to tell you a story, hopefully not too long a story. When I first started practice, I was the only woman in the family law department, only woman in most of the courthouse. We're now talking about 53 years ago. There was the supervising judge of the family law department was actually a woman, probably the only judge in the entire department. Anyway, I was scared witless to go into court. I had no idea. I had no mentor. I had a partner who was not able to do litigation. I had no one to look up to. I walk into court one day and I see this attorney who I had very high regard for. He had written a book and he was like everybody's God. He gets up on a contempt matter and he calls as his first witness the contemnee. I'm thinking to myself, I think I could do this job. What a moron. So, and this is most of my career had to do with trying on my own. I didn't have anyone that was going to train me. Women were not, they called us girls. But it's not only whether that we were women or not. There was nobody who was willing to stand up and mentor us. So pretty much I had to do it on my own. And I have to say, I did a pretty successful job. And now, as you know, my son is my law partner. Now there is brilliance, if I do say so myself.
So, I think a twist on that was a good plug, Alice, for the continuation of the firm, but it is the motivation part that I'm curious about, right? So, and I want each of you to weigh in on this, but Larry first, what motivates you to continue working in family law and keeping what keeps your energy up? Why is this still such a great thing great profession and thing for you to keep spending your time on?
I think it's a great question. We could all talk for hours about it. It relates back to the prior question about kind of that moment or that feeling of confidence and how that's instilled in one. What I hope for everyone in any profession, but certainly in the profession of practicing family law, are those moments when you hang up the phone after a difficult conversation, or you come out of court, or you spend hours and hours mediating a really productive ultimate resolution. What I hope for everyone is that moment when that you're kind of in the right place, doing the right thing that resonates with you. I'm very fortunate to have that feeling and that experience regularly. And when I was talking with a friend the other day about retirement, because we're all at the age where we think about things about what our futures look like. And for the record, no plans of retiring in the near future for me. Can't speak for anyone else. But the idea is, as long as I have that feeling, as long as I feel like that conversation or that participation in litigation or mediation or creative, resolution, that makes me feel like I've accomplished something for the client, and more importantly, for his or her place or the family's place in kind of their world and where they live and moving forward. That's everything for me. I love my firm. I love the people I practice with. I love the vast majority of my colleagues. Not everybody, but that ability to have that feeling, that's what keeps me going. I have great pride, take great pride in the firm that we built here. I still think that is an accomplishment beyond anything I'd ever thought I would accomplish. And I've accomplished it. We've accomplished it because of the relationships with people at the bench and the bar and the world around us. And to have that kind of drive and that motivation, it's self-fulfilling from my perspective. So I just wish that for everyone, to have that moment, hopefully regularly, where you feel like you're in the process where however you're built, however you're wired, it resonates with you and makes you feel that you're accomplishing something to give back. And that's, to me, the ultimate importance.
Neal,
And drive.
Neal, what's your take? What motivates you to continue?
Miserable. Everything's miserable. No. No.
Or just tell us like Larry, tell us everybody that you hate on the bar. We'll pivot to that.
So the truth is, for me, and I mentioned this, I think, to Dan the other day over a call, what we do, we're very, very lucky. And without sounding maudlin about it, every day is another challenge intellectually. We learn something every day. After all these years, we do this and we think we've seen it all. And then somebody comes in and I'll say, geez, I never saw this before. I have to look this up. And that the intellectual challenge keeps me going. I also, along the lines of what Larry said, I think we are, and Alice both, I think we are helping people. That's our task when we take on a case. My task isn't to obliterate the other side. It's really to help my client. That gives me fulfillment internally. Again, this is my own internal metronome, judging this. And yeah, I think that a sense of accomplishment for a day well spent and a client well served is very, very fulfilling. And if you're not fulfilled in your work, I mean, how many people are miserable with their jobs? Thank God the people on this call are not. And that's very, very fulfilling. So as long as I'm being intellectually challenged and fulfilled, I'm going to keep doing it. That's it.
Alice, I want to put a twist on that for you, because you already talked about your son and the legacy within your practice itself, the firm, and now it's a multi-generational family thing. Broadly speaking, I want to talk a little bit about legacy. Where do you, what impact do you want to have, not just on your family, because that's such a different twist on it, but in the community more broadly? What would you want your legacy to be, or what would you want all attorneys to be able to learn from you?
First of all, I would love to retire, but my son is not letting me. Okay.
Does anybody know a good elder abuse attorney?
There you go. There you go.
I don't know.
I don't know if I intend to or ever intended to leave my mark on anything except to help the particular client. And the truth of the matter is, the reason I've stayed in family law is I'm a voyeur at heart. I get to see the inside of people that their therapists, their doctors, their mothers, their cousins, their best friends do not see. And that is what has motivated me all these 53 years. What do I hope to see? I'd like to be able to go see more of the opera. I want to travel more. I want to do all these things, and I can't because I need another lawyer in the office. Anybody available out there? That would be nice. So I forgot, what was your question?
No, what difference does it make?
Yeah, right.
No, I think I want to talk just in terms of legacy in the future. There's this idea, and you touched on it a little bit when we were talking about the judges, Alice and Neal and Larry. I'm glad we had even just a minor bit of conflict today at least in terms of how we view the bench and the turnover. But it does feel like when we talk to colleagues, that there is a sense that the practice is changing, and I don't know if that's technology or the wealth dynamics in Los Angeles being different, but there's something there. Maybe it's this generational shift in the bar. I don't know. What, Larry, do you see at the kind of the significant changes either in practice or in the community in the recent past? And are there any emerging trends that you think will transform the practice of law, either good or bad?
Well, let's start with the obvious. What I think is potentially bad is the whole AI development and everything else, and the reliance. And we all have clients. I can't speak for Alice and Neal. I certainly have clients who, God love them. They'll send me like a 3-page explanation of a certain issue. I'm like, oh, this is not something they wrote. This is like straight out of ChatGPT.
Yep.
And of course, you can kind of call them out diplomatically on it. But the development of all these technologies, but this is a human to human practice. This is an inherently personal practice. And so I think that this practice continues and will develop. Certainly, electronic access to the courts as a result of COVID and how those develop, I think is a good thing. I do agree with Alice. Face-to-face is much better for the discussions and the understanding of how people are and how they're acting and interacting. People who hide behind electronics, and I'm guilty of it. Sometimes I don't want to have that conversation with Alice. I'll send her an email just because I'm tired and she wears me down. It's like, so that's got to happen. But I think the electronic, the ability and social media, it's particularly in the context of our practices and custody cases, social media has been a huge change, and not in a good way. I mean, the issues, I say this consistently to my clients with kids and grandkids, the ability to raise children in the world that we're living in now, as opposed to when I was a kid and, growing up in Wisconsin in the 60s and 70s, vastly different. And I have to try to understand that in the context of advocating and representing interests. But the thing that overriding for me on the practice is I have a large international practice, a lot of work through my connections with IFL, and the kind of globalization of the issues we deal with in certain cases, especially in certain kinds of cases. And I talk to colleagues all over the world. We're all dealing with the same issues. We're all dealing with the same dynamic, the same frustrations and positive, negative, and how we get through it. But that kind of the flattening of the world around us so that we have an ability to reach out and experience that in a much larger context than simply our couple in Beverly Hills or otherwise, to me is the biggest change. It's a vast world out there that is becoming smaller and smaller and more interconnected. And in family law, I think that creates a whole new dynamic for how we practice, how we integrate kind of the international, jurisdictional, and other issues into what we do. But the AI thing that's going to be tough. It's going to be scary going forward.
I have the same problem with a client here or there who sends me a clearly AI written workup.
Like, what is this?
Yeah, really.
The bullet points tend to give it away, and the formatting. But the natural question that comes up when thinking about these issues, about these changes, is how do we deal with them? How do we address them? And I'm wondering, Neal, what your thoughts are on how not just young lawyers, but all lawyers now can deal with these changes that are happening in our practice.
So I'm a bit of out of touch with some of the new technology that I have to push myself to learn. That's part of what we have to do. So, but by the way, I'm not going to learn it as well as the younger lawyers who are here, and I have to just realize that and face it. So, by the time, however long the practice for all of us is going to be, I'm going to need some knowledge of it, but I don't think I'll ever have to be, conversant with it to a huge degree. So I have to navigate it at some level, but I'm not really worried about it in others. It's a fact of life. Larry said it, and he's right. It's a fact of life. We have to deal with that. Just like we had to deal with preservation of electronic evidence and how do you subpoena that? We had to learn how to do all that stuff. So there will always be evolutions. listen, I used to say that some of our social values we're expanding faster than our laws that we're keeping up with them, right? And now some of our technological advances are expanding more quickly than certainly I can learn them, to a high extent. So we have to have people here who can do that, and I have to learn it at some level to make myself at least not completely oblivious to it. But yeah, it's going to go on indefinitely. That's for sure. We went from Zoom and Teams. I mean, that's become the norm now. It wasn't the norm 4 years ago, right? We just have to evolve with the times. That's all you can do. And by the way, if you don't do it willingly, you're going to have to do it unwillingly because the practice is pulling you in to do it. So it's going to happen one way or the other.
And by the way, to the younger lawyers out there, be kind, be nice to us.
Right.
Don't judge us for our lack of
Absolutely.
it. Don't judge us because I'm a dinosaur,
Really.
Or they risk becoming roadkill in the hallway instead of
Uh-huh.
a warm arm on the shoulder,
go.
Right.
at least from Alice. So, Larry, we're almost out of time, and I want to pick up, and you kind of led me right to where I wanted to go to finish, and maybe just, a few seconds from each of you, because I think one of the things that I've learned by working with all of you is this connection between empathy and resilience, because you don't get to be a legend. You don't have these kind of careers, and you don't have the kind of reputations that all three of you have without both of those things. So I'm curious, as we wrap up, how either you've been able to do it and stay fresh and keep this balance in your life, where you're able to maintain the right perspective, or how you think new attorneys should be cultivating their own empathy and their own resilience. Alice, why don't we start with you, and we'll just kind of go quickly through it.
It reminds me of a time this was in front of Judge Denner. I think he was still a commissioner, I'm not sure. But I had a case before him, and he asked both sides, how long would this case take? And I said 10 days, and the other side says 3 months. So Denner turns to me and says, how could this take only 10 days according to you? I said, I only have 10 outfits. And it did last 4 months. So, but you don't really have that many cases that go like this over a period of a continuous 4-month period. And you have to steel yourself at that time. You have to learn how to stay the course. Otherwise, your client is going in the middle of it, is going to change for another attorney and leave you with the bills and so on and so forth. How do you handle all of this with the new technology? I want to tell you a quick story. I was sick one day, went home and looked at one of the declarations or points of authorities. And I'm looking at this, I'm thinking to myself, who the hell wrote this? It was quoting a code section that the code section existed, but it was quoting was not what was in the code section. And I knew that. I looked it up again. I said, this frickin' AI, I can't stand it. Nobody is going to use it. So of course, I can't stop anybody in the office from trying. I said, but if you're going to use that thing, you are going to have your head chopped off if you're quoting the wrong thing. And so do we have to go and get up to speed? No, I'm not going to be using AI. Let Ariel, let Preston, let Terry, let everyone else in my office do that. I'm on my way out, let's face it, okay? And so I just have to do what it is that Neal and Larry and I have learned to do. And we still have to keep in mind that this is a family law practice. Our clients' lives, their futures, their children, and their children's lives depend on how successful we are going to be either in mediating with each other, settling, or in court. And that's our job. That's it.
Neal, how about you? How have you had the resilience and the balance, and what would you tell other attorneys so they can cultivate the empathy and the resilience that you've been able to manage?
So I want to talk about resilience first. You have to know when you've had enough for the day or the week. So when I was a young lawyer, I thought I was going to quit the practice of law because I lived it 24/7. I couldn't be away from it, and it was affecting my personal life. Then I don't know. I just realized that can't be the situation. And if a client would call me and say that her refrigerator or his refrigerator was broken, and I would be frustrated, I'd realize I need a break, because that, when we think is silly, that client's calling you in distress. They need your empathy. They need your focus, right? And if you can't give it at that moment, okay, then it's a sign that you need to go take a walk, get some fresh air, do something. And thank goodness it doesn't happen much in our practice, my practice, but if it does happen, I am constantly on watch for that. So you have to be empathetic to our clients. And obviously our business is stressful. I don't care whether you're a legend or not a legend. This is not for the faint of heart. Also, it's not an acquired taste. You can't say, I think I'm going to try family law and pick at it here and there. You either have an aptitude and a taste for it, or you don't. It is just not an acquired taste. So because it is difficult and stressful, you need some resilience. What do? Maybe you read, maybe you go to the gym, maybe you go to the opera. You need some outlet to fortify you so you can have the resilience you need for the job. And you obviously need some empathy, because your client wants you to be a warrior, but you have to be a sympathetic warrior, an empathetic person to deal with your clients on a daily basis. So you have to obviously meld those two together. And thank goodness the three of us have been able to do that successfully.
Larry, you're the newest addition to this club, so let's end with you. Where do you feel like you're at in that journey in building in building off of that and sharing that approach with others?
I want to pick up on something that Neal mentioned about being intellectually challenged every single day. And I say this to people all the time. It's like every day or every few days, whatever happens, I'll hear something from a case and some dynamic. Human nature is a weird and wacky animal. And I'll hear something and I'll walk into one of my colleagues' offices or call somebody and say, okay, here's something new. Here's something I've never heard before. And what do you think you should do with this? That intellectual challenge, that whether it's procedural, intellectual, substantive, whatever it is to me, again, one of the driving forces of this continuation of our practices. But my watchword, and this goes to the resilience issue and the empathy issue, and really kind of as we move through this practice, which is, to Neal's point, an extremely tough practice that we have chosen, extremely tough on a variety of levels. And the resilience and the empathy are both hand in hand, excruciatingly important. And if I had to summarize it in one phrase, to the extent possible, don't take it personally. I mean, have the conversation. To finish this with another Joe Tabak story, walking out of court with him one day, young lawyer, and he, as we're walking out of the second floor into the courtyard area, he puts his arm around my shoulder. He said, "How come you're never bothered by the, excuse my expression, shit I throw at you? You're never bothered." And I remember thinking, this is Joe Tabak, and why is he having this conversation with me? I was suspicious immediately. And I looked at him and I said, "Joe, I consider the source and I move on." I just don't, I have, because of my upbringing, maybe, or whatever, I don't know what drives it, I'm fairly even keeled. I just have an ability, as I think all of us do, to not take these things personally. This is our work. It's important. It's hugely important. But if people are mad at us or people are yelling at us, probably it's not about us.
Right.
Probably it's about some other issue. And to take a deep breath, to Neal's point, take a walk. And it's very importantly, don't type that responsive email and send it immediately. Let it breathe. Let it breathe.
Yeah.
Maybe pass around one of your colleagues to see if it's really important. But taking that moment and doing your work for the advocacy of the client, which is paramount, but not taking it personally and engaging, as some people like to do, I think is the secret, personally, to a longevity in the career and longevity in the satisfaction of the career, not just professionally, but kind of personally writ large. That's what I would suggest.
Well said.
Yeah, that is well said. And I think that's a perfect place to end it for now. I think we'll probably have you guys back because we barely scratched the surface. I know there's dozens and dozens more war stories and lessons that we can learn from all three of you. So It goes without saying, we can't thank you enough for spending so much time with us. Neal, Alice, and now Larry, you are legends in every sense of the word, award or not. But this was such a great reason to bring this group together. And truly, thank you for being
Our
so
pleasure.
generous with your time and with our bar.